Next Wednesday, minor.
Next week, not possible. Come on 3rd of June.
Some early pension matter, minor.
Early means all the dates are, well, there are other matters already there.
Also, one of
25th.
it.
Similar prayer because this matter on 21st.
Yes.
Yes.
I'd like to mention item number 43
Hmm.
for withdrawal matter. But we have some mistake in hiding the verification minor. 43 minor.
43, Mr. Bordeloi, learned
Borua.
Borua, learned counsel, appearing for the
Petition.
43 and 44,
And 45.
45. They're all
Connected.
Connected.
But minor only one minor we want to.
okay. 43, the counsel for the petitioner submits that some error inadvertently was noticed after the matter was filed. Therefore, he seeks liberty to withdraw the same and refile.
And lordship with
Prayer made is not objected to by the counsel for the respondent. Accordingly, writ petition 217-2026 be separated from WPC 673 stands dismissed on withdrawal with liberty. It stands separated from 6730 and 7287 of 2025. The other matters be listed separately.
Lordship, with regards to item 44, the same series, Lordship, I need some time to file my affidavit. In 45, I have filed. 44.
It will come after 3 weeks.
Obliged.
Yeah.
For listing in the higher manner, for name correction in the order manner, passed by
Friday.
For listing of a urgent writ petition.
Friday.
I'd like to listing for withdrawal the petition.
Tomorrow.
Wait, please, Your Lordship. I'd like to mention item number 15 of today's list.
52.
15, 15. Yes, Mr. Ashish Das Gupta, he could not attend the court today. So may I pray that it may be fixed after on Wednesday.
Wednesday. Today is Wednesday. Next Wednesday.
Then next Wednesday.
On the request of the Mr. S. Doctor Counsel representing S. Doctor for the petitioner, matter stands deferred. Be listed on 20.
Obliged.
Yep.
Please, Lordship. I have for listing Lordship for admission.
Admission.
Yes, Lordship.
3rd June.
Yes.
Please, Your Lordship, I beg to mention for listing of a press motion matter, matter. It's regarding wrong fixation of grade pay matter for Friday matter. The
Friday.
petitioner obliged.
Beg to mention for a listing of an admission matter on Monday.
3rd June.
Maybe Your Lordship. I beg to mention listing of one is admission, one is quarters matter.
3rd of June.
Obliged.
May please, Your Lordship, I beg to mention for listing of matter for orders.
Orders. 1st of June.
Much obliged.
Lordship, with the consent of the other side, I beg to mention item number 39 of today's reading list. And for the petition. Lordship, in this matter, we've received our pair-wise instructions and we'd like to file our affidavit.
39.
Yes, Lordship.
On the request made by Mr. M. Huya, standing counsel, matter stands deferred to be listed after 3 weeks.
Lordship, 2 weeks, Lordship, because there is no interim, Your Lordship.
2 weeks.
On 29, may I pray for a date, Your Lordship? There is no interim, Lordship, that's right. 29.
You make a mention after the affidavit is filed,
Yes,
at least after 2 weeks, enabling them to file the affidavit as it is submitted that the instructions sought for have been received.
Much obliged.
Mr. D.J. Das appears for the writ petition.
Much obliged.
Your Lordship, I would to mention item number 24 and adjourn the matter for the day, Lordship.
24 on the request made. You are for the petitioner?
Yes, Lordship.
On the request of the counsel for petitioner, matter stands deferred to be listed after 1 week.
Maybe I beg to for listing of petition matter. The matters related to the service of the petitioner. Maybe it should not take Lordship any date.
3rd of June.
Maybe too long.
Why?
Because the matter related to service of the subject.
Service of?
Service of APTSL department, Lordship. It is selected but illegally during the time of verification.
We'll examine that.
His selection was cancelled. So after
When was it filed? Was the writ petition filed?
In the month of January, Lordship.
So wait till third of June. 3rd of June. Yes. View the submissions made by the counsel for the petitioner on instructions that the writ petition does not wish to press the petition any further. Accordingly, writ petition stands dismissed on withdrawing order and stands vacated pending either of the dismissed.
There is no impediment.
If any.
I am.
The submissions made by the counsel
Matter have been amicably settled between the
petitioner that the matter has been settled amicably outside court. Writ petitioner does not wish to press the petition further. Writ petition stands dismissed. As not pressed, interim orders, if any, stands vacated. Pending ayes are also dismissed. Notice. Third counsel for parties issued notice. Returnable 4 weeks. Mr. Prohibitions, then as CGC represents the respondents, therefore notices are waived. Extra copies will be furnished within a period of 1 week.
And
Respondents may file their objections if any.
I'm representing H. Gupta CDC. I'm not.
On behalf of Mr. H. Gupta.
CDC. Obliged.
I think. Issued notice, returnable 4 weeks. Mr. R.A. Tobildar, on behalf of Mr.
H.
H. Gupta, appears for all the respondents, therefore notices are waived. Extra copies be furnished within a period of 1 week from today. Steps, extra copies be furnished. The respondents will file their objections in any meantime. Same order, right, 3, same order.
Obliged.
This case was the appointment of arbitrator one.
Third counsel for parties issue notice, returnable 4 weeks. Mr. A. Botagu appears for the private respondent.
No, madam.
Sorry, the sole respondent. Therefore, notices are waived, extra copies will be furnished within a period of 1 week. The respondents may file their objections, if any, in the meantime.
In the meanwhile, if Lordship by learned friend agree, my lord, then suppose he has
I
no
will
objection.
have to take instructions. My lord, if I may pray, my lord, soft copies of the petition may also be shared.
No
my
problem.
The counsel for the petitioner is given the liberty to furnish extra copies in soft copy to the standing counsel.
Well, item 4 to 8, identical.
4 to 8, identical.
Obliged.
Notice that Mr. Sanjay Sharma, petitioner in person, issue notice, returnable 4 weeks. Who's the CGC? CGC here? MS S. Burwal and CGC appears and accepts notice on behalf of all the respondents. Therefore, notices are waived. Extra copies be furnished within a period of 1 week from today. Respondents are at liberty to file their objections list after the returnable.
Fixed date can be given, it will be better for.
Fixed dates.
Be better for.
17 June.
17 June.
Obliged.
Wait, listen. Order page 15. Well, 11, 25, page 16. 11 portion, my lord, to page 19, paragraph 8.
19.
Page 19, paragraph 8.
No, what has happened after that?
After that, my lord, they are not processing my payment then. Nothing.
You are the second wife,
I am the husband.
first wife.
First.
Heard counsel for parties alleging willful disobedience of the order dated so passed in WB. Its contempt petition has been filed. There I issue notice, returnable 4 weeks. Steps on the respondents by speed post within 1 week from today.
Yeah, they date, my lord.
You take steps, there will be returnable service report, etc. What is the point? Once the service is complete, matter will be listed.
I'm the.
Matter to be listed after completion of service.
After 4 weeks, after.
Yeah, please. This contempt petition, my lord, not. Order is at page, my lord. 11 part is page 16, my lord. For regulation of his service within a period of 3 months, my lord.
Heard counsel for parties. Issue notice, returnable 4 weeks, alleging willful disobedience of the order dated so and so, passed in WBC so and so, contempt petition. Right. Issue notice. Returnable 4 weeks. Steps on the respondents by speed post within 1 week from today.
The sheet, my lord, here I'm supposed to file my reply, but however, the petitioner could not come. He's on duty.
MS so and so
I
prays
pray-
for 2 weeks time.
No, I pray on for Friday, my lord. Since here we are
After 1 week.
we are challenging the transfer order, my lord.
So not filed.
But it did
When will you file?
by tomorrow, my lord.
So by tomorrow you will file the file. Why this hurry? Why you putting pressure on the registry?
Since there is no
Monday.
interim-
Based on Monday.
Obliged.
Wait, your lordship, can the item number 13 and 14 be passed over for the time being, your lordship? For
We
the-
thought we'll dismiss it. No.
No, for the, senior counsel has asked me to make a request to this honorable court, only for 5-10 minutes, your lordship.
5-10 minutes we can pass over. We'll have to call it at the end of the list. End of the motion list.
Yes, your lordship.
Yeah, because. Also, the previous date instructions were sought for my lord.
Yes.
Accountant General directed to take.
Yes.
Accountant General, who's for Accountant General? By the earlier order dated 8/5/2026, the Mr. B. Chakraborty, learned standing counsel, Accountant General, was permitted to obtain instructions. When the matter is called, Mr. Chakraborty is not available. Release this matter on Monday.
My lord.
A copy of this order be marked to the office of the Accountant General.
I have got 3 to 10.
May I have Ms. M.D. Bora for
3 to 10.
3 to 10, MSA Bora for
Obliged.
May, your lordship.
yes.
But the Panchayat department, the Assam State Rural Mission Livelihood Mission, in collaboration with the Jal Jeevan Mission.
Where is the extension order?
My lord, the extension order is at page 686. Up to 27.
Periodical extensions.
Up till 31st March 20.
Where is the last extension?
This is the last. I am here up to page 86.
Ah.
That I am there till 2027.
Okay.
And the terms and condition for me to terminate is at page 78. The Lordship may look into it. That I should be given a 30 days notice, page 78.
What is ASRLM
ASRLM
Assam
is
State.
Assam State Rural Livelihood Mission.
and JJM?
JJ Jal
Jal
Jeevan
Jeevan
Mission.
What is this MOU for?
Well, that the advertisement and the terms and condition starts at page 78 and the relevant portion is at page 81. Terms and conditions. The contract with the young professionals may be terminated by either side at any point of time during the contractual period by serving a 30 days notice without assigning any reason and without thereby incurring any liability to the SRR. So there that was not provided. And the human resource manual,
Notice was not given.
nothing was given. No show was nothing, just done. But my instruction was from my friend that I have not been released till now. The impute order is at page 98. One human resource manual is there. I have annexed here with my lord. It starts at page 18. The relevant is at page 59. Where it's
Where is that? Where is the termination order?
termination page 98. My name figures at page 99. Serial number 12.
Page number, serial number
12.
12.
Your Lordship, just I trouble your Lordship to page 59. The human resource manual, it states that termination of contract, that is 9.1. The contract signed between such and such an employee may be
Page number?
page 59. That is the termination of contract. The contract signed between SLM and an employee may be terminated based on the following ground. So the grounds laid down. But because there is a terms and condition to my appointment order, the appointment order is at page, my lord, 83. Engagement letter, page 85.
Union S Burua appears for 5 and 8. The petitioner is aggrieved by the termination, common termination order issued on 24/4/2026, whereby the petitioner's services as young professionals engaged under the Assam State Rural Livelihoods Mission stood terminated. Stop. The learned counsel, senior counsel for the petitioner submits that in spite of the extension granted to their appointment orders by the last extension order.
Page 86. 7425.
11/4/25, which was to have effect, which was to continue till 31st March 2027, and without following the procedure prescribed of issuing prior notice, the termination, impugn termination order has been issued. And it is further submitted that the petitioner is still
ये बड़ी गलत चीज है तो
Holding.
काम कुछ और करो बैठ के
the counsel, respective counsel appearing for the stay respondent, submit that instructions will be necessary. Accordingly, let notice issue returnable 2 weeks. Since the respondents are represented, notices are waived, extra copies be furnished within 3 working days. And till the next returnable date, the impugned order of termination, so far as the petitioner is concerned, shall not be given effect to. Matter be listed again on 5th of June.
Public.
Public.
Yes, for there will be my lord to take up this matter along with item number 45.
45.
45, common cause of action, my lord. Here, the selection process is under carrying.
You are arguing this matter or 45?
Here, my lord, till the time, my lord, my respectful prayer will be to take up this matter.
I know.
Item 18.
We can take it up now.
My lord, file is reaching, my lord.
Say that.
I'm
Counsel
sorry.
for the petitioner submits that this matter be called up along with the
Item number 05, my lord.
45.
I'm obliged.
Order given away. Mr. Tapadar, my postmaster informs 45 has been mentioned. We'll list it after 3 weeks together. Matter be listed along with WPC 6730 of 20, but those matters are coming for admission. Your matter notice has not been issued.
Notice has not been issued.
We'll issue notice.
I am deeply obliged.
Heard counsel for parties issue notice returnable 3 weeks. Mr. DP Pora appears for all
Yes, my lord, all there.
the respondents. Therefore, notices are waived, extra copies will be furnished within a period of 1 week from today. It is submitted by the counsel for the petitioner that the issues raised in the writ petition are similar to the ones which are urged in WPC 6730 of 2025 and WPC 7287 of 2025. So he submits that this writ petition be listed along with those 2 writ petitions. Prayer made is not objected to by the counsel for the respondent. Accordingly, let this matter be also listed after the returnable date, along with WPC 6730 and 7287 of 2025.
Obliged.
I'm obliged.
Yes.
Ned,
Huh.
but the petitioner has been suspended by the executive officer, my lord, the chief executive officer, Hailakandi Municipality Board, my lord. Annexure 7, page 31. But it was issued on my lord 5/1/2026. The authority of my lord, the appointment and this disciplinary authority has been taken up by the director. So the legislation, it was passed on 16/6/2025. Well, without approval of the appointing authority, they have not taken any neither approval nor.
Where does it provide?
As per my lord, the rule 6 of the Assam discipline service.
Rule or section?
Rule, madam.
of the
Assam Service of Discipline Civil Appeal Rules 1964.
not unable to understand whose approval is necessary.
Director, my lord, because the my lord, Lordship has page NXF 5, page 27. This is the order of provincialization issued by the director, whereby the services of the employees under the board has been taken up by the government. The petitioner is at serial number 1,
Head assistant.
head assistant.
So
So the as per the 1964 rules, my lord, the appointing authority has to is the disciplinary authority, my lord.
no.
And even in the event if the subordinate authorities my lord, place him under suspension, then that the order has to be approved by the appointing authority.
Which
Rule
provision?
6.
Rule 6. Yes. It begins with appointing authority or any authority.
Any authority,
Oh.
but in the event any authority lower than this my lord, appointing authority, then the suspension order has to be given effect with the approval of the appointing authority.
Under what provision you are saying that?
In this rule itself is written.
Point out to the rule. Huh? It is only required to report, not
Yes.
take prior permission.
After the suspension, my lord.
Ah,
Yes,
so how do you say that it has not been sent?
it is not been sent, my lord. It is not been approved.
Third, counsel for party issue notice returnable for X S41. The state council hears accepts notice on behalf of
1, 2, and 3.
1, 2, and 3. Therefore, notices in respect of 1, 2, and 3 are waived. Extra copies furnished within 1 week from today. Steps on respondent 4 by speed post within 1 week. That will be listed after the returnable date.
But 90 days by this time has been over from the date of suspension, my lord.
Pendency of the writ petition shall not be a bar. Pass effective orders for reinstatement of the writ petitioner if the authority is deemed fit and proper.
Right.
For pardon for non-payment of provisional family pension and gratuity, my lord. At which stage notice may be issued.
Counsel for parties issue notice returnable 4 weeks. MS Lorwa, then CBC.
No, step test.
State appears and accepts notice on behalf of respondent number 1, 2,
4 and 6.
4 and 6. A Port Harcourt appears for respondent number 3,
3 and 7.
3 and 7. Who's for 5? Accounts and treasuries.
Also represent finance, my lord.
By 5,
5 also.
A Port Harcourt, 3, 5, and 7. Since the respondents are represented, notice says a waived extra copies be furnished within a period of 1 week from today.
Pendency shall not be a bar, my lord.
Pendency shall not be a bar. We will read the grievances raised by the writ petitioner.
Oblige. Petitioners herein are all external workers. They were appointed since 2005 onwards for a period of 5
You
years.
want benefit of open dust.
Yes, your lordship, because they are otherwise eligible. But one thing has happened. Now they have issued an your lordship an order that your lordship find at last page, page 138. Now the order dated 14/11/2025 has put a bar to the fact that in the second line itself, second line, payment of minimum pay scale to master rule so and so fixed pay. Similarly, place worker engaged prior to AFRBM. This was introduced, which is not there in the main judgment. Your lordship. This will, in fact, though there are 10 petitioners out here, your lordship, 2, 3, 4 petitioners will be affected by this. Otherwise also, your lordship, as per the order dated 18/10/2020, their names have not been. So at this stage, I think my learned friend will require instructions. Notice may be issued.
Heard Mr. Y. S. Mannan, learned counsel for the petitioner. And Mr. D.P. Bora appearing for the Health Department, MSB Bora for the BTC. And Mr. C. Barua for the Accountant General. Petitioners are agreed that in spite of rendering services or since
Since 2005,
2005.
more than 10 years, most of them.
And for more than 10 years, their cases have not been considered for payment of minimum scale of pay as I mean, in terms as have been done to other similarly situated employees across the state in terms of the judgment and order dated 8/6/2017 passed in Writ Appeal 45 of 2014 in bracket state of Assam versus Upendas. Petition, the counsel for the petitioner is agreed by the, you're challenging this order?
Yes, that
138
is also on the check.
dated
this is one-
14/11/2025, whereby the Finance Department has issued an executive order that the benefit of minimum scale of pay to master role workers will be made available only to workers who were engaged prior to the AFRBM period. Stop. The learned counsel submits that this executive order has the effect of expanding the scope of the judgment and order dated 8/6/2017 passed in Writ Appeal 45 2014 and which is not permissible in law. Under such circumstances, the petitioners are before this court assailing the actions of respondents. And having heard counsel for the party, issue notice returnable 4 weeks since the respondents are represented by the respective counsel. Notices are waived, extra copies be furnished within a period of 1 week from today. Pendency of the writ petition shall not be a bar for the respondents to examine and give due benefit to the writ petitioner if otherwise they are found to be eligible.
Much of it. In fact, your lordship, respondent number 1 is the finance.
Finance is appearing.
The impute transfer of the petitioner has been silenced here, my lord. Annexure 19, or page 19, annexure 2. A relevant portion at page 21. Medina Buraguhai, she has been transferred from IOC Gauhati to Pokrajar SPSS Salakati. That is a unit so far she has been transferred, my lord. So prior to the issuance of this transfer order, the respondent authority asked the petitioner to submit her choice of posting. So accordingly, my lord may come to page 25, the relevant portion 27. That was her representation submitted on 22nd 1/2026 in the last para. Hence, under the facts and circumstances, so and so. I may be exempted from annual transfer by allowing me to continue in my present unit under the aforesaid facts and circumstances. Hence, I pray for extension of my tenure in my present for the department for at least 1 year for my convenience. If my transfer is unavoidable, the competent authority may earmark me for transfer as alternative measure at any Guwahati-based unit as my choice of posting, CISF unit OPS Sunmati or CISF NES headquarter Guwahati. That choice was submitted prior to the issuance of the transfer order, and after issuing that transfer order at page 28, Annex 4, she has again submitted the online grievance. There also specifically she incorporated her problems. The ailing parents, due to the treatment of the ailing parents, because they are the dependent on her. Only she is the caregiver, and she has to take care of her parents in respect of all medical treatments and all.
Is there an exemption from transfer under any circular rule that if you are the caregiver, then you are exempted?
So far, in the circular, that has not been mentioned specifically. But at page 29, your lordship may come to page 29. At the last,
No, you tell us under what provision are you asking for a stay of the transfer? You are a member of the All India Service.
yes, my lord,
Transfer is a condition of your service.
at page 29, my lord, because I was asked to give my choice of posting, my lord.
Choice of
Accordingly, I
posting
submitted.
is all right, but there is no,
Here, they have
there is no
observed,
ground that
by regretting the representation, they have stated, her posting has been issued on the basis of her choice given by the individual.
you are
under the-
posted where?
I am posted at SBSS Salakati, my lord, from IOC Gauhati.
Ah.
So that is
And
the
what is your
problem.
choice?
I submitted my choice any CISF unit Gauhati based, my lord. That is CISF unit OPS Nunmati. That is one, and the group headquarters Gauhati, my lord. So they have observed that they have given me the transfer on the basis of choice given by me. That
You
choice was,
first tell us that you have a right to be considered, to be posted in X place or Y place. Under what provision?
because I was asked to give my choice, my lord, and under some
Is there a service condition that you will be only transferred to these 4-5 places and not beyond? Is there a service, is there a circular or a rule to say that if you give your choice, those choices will have to be followed?
now I am just on my home sector. So that is why they have asked me to put the choice. Accordingly, I put the choice with the regions, my lord, ground cited. with
Whatever
the-
it may be, there will be hundreds and thousands of people like you. How will the service be conducted if everyone chooses their home state?
And at least for 1 year deferment, my lord. Specifically, that is
You are
mentioned.
before a writ court. You have to establish your right. You establish your right. You establish that yes, this is your right which has accrued and was wrongly considered or not considered. We'll examine it.
So far, the representation reflects of their order.
Reflex says that
29.
given a choice,
So,
whoever
on the
within
basis of my choice, they have
Salakati
contended.
is in Assam only.
So, choice so far given by me is the OPS Nunmati and the group.
We are not convinced. Yes.
A woman personnel or through e-system can give 10 choice of posting. She is here for more than 4 years in OPS Nunmati. She had given choices posting, and we have transferred her to SSB Salakati, which is her third place of posting, because the other two are in Gauhati, which is she is here for last 4 years.
But where has she given this choice?
Yes, Lordship. She had stated she had given Kokrasar as her third choice of posting.
Where?
In my representations, as I have already at page 27,
It is there in her petition.
because that was submitted prior to that posting order 22/1/2026. I submitted, my lord. Specifically, I have mentioned at the last period.
Where is Kokrajhar?
It is in Kokrachhar,
No. Where is the choice given?
Lordship. In yes, page number 32. Lordship, page number 32.
Hmm.
There, Lordship, accordingly, she uploaded her choice of location in the relevant tab on the Empower website, along with her request application so-and-so address to so-and-so, which was uploaded. Her seeking exemption from so-and-so for 1 year or alternatively posting to CISF unit OPS Nunmati, copy and close. Subsequently, her posting has been issued to so-and-so SSB Salakati under district Kokrasar, which was her third choice.
So that is given, but OPS Nunmati is mentioned, my lord. They have also.
She is here for more than 4 years, and the grounds, Lordship, out of 3 grounds, she was in the home, not in Gauhati, but in the Kokrasar Lordship, in the state of Assam. 2 grounds is that one, she is buying a property, and second is she is looking for a suitable match. Those two grounds is not accepted, Lordship. And third ground, her parents are not, if Lordship will see that one mother is suffering from osteoporosis and father has some, it's not that she had to stay with them all the time, Lordship. And Kokrasar is not a faraway place. And the last occasion also, after completion 3 years, the same grounds he has stated. And
Now, is there any circular that such benefits or exemptions are available?
some in some cases there, but this is probably not included in that list. Because Lordship, if Lordship see the medical document of the of her father at page 36.
So they have also.
No, that impression is that mild diffuse brain atrophy without any focal parenchymal lesion and no obvious fracture of the cervical spine. And so far, her mother is concerned that she is suffering from osteoporosis and she has to, if she is not taken care of, she is in high risk of fracture. So that is 65, 70 years. That can be happen if she is in Gauhati also. So it's not, and all the time Lordship. There is no malafide in our part.
Page 32, she uploaded her choice of location, either 11th lab on the.
No, Mr. Counsel, we are asking you repeatedly, is there any rule, is there any notification which gives you an exemption or a choice that has to be considered before issuing of these transfer orders? Or is it a case that you are in a service or you are in that particular post where transfer is not ordinarily?
There is no such specific,
Then-
my lord,
then-
but so far it is reflected in their.
No, so on what
Order
ground,
itself.
on what ground are you challenging it?
Because I was asked to give my choice, that is also
So
admitted by them.
Is
so
there
far
a,
at page
is there a
32.
compulsion that your choices will have to be given? No, it is a matter of convenience. They have a courtesy extended that you give your choices, we'll
But
see.
they are contradicting themselves, that is why, my lord. Here at page 32, they admit.
You get the instructions, what choices has she given?
She given these two choices of Gauhati as her first two and third is Kokrajhar.
No, so where is that third Koprada?
It is not reflected here. in
It's
their-
my instruction is that,
You give it, you show us on what basis. Get that copy.
Lordship. Even in this 32 page number, it is written, which is a that I have
Subsequently, she is transferred, it is written only, but. so
page
far-
32, Lordship,
Ah,
and XR 5.
I can't see that.
According-
Where is it?
Yes, Lordship.
according-
So accordingly, from bottom, Lordship will find it.
Accordingly, it's submitted.
From bottom 11 line, page 32.
Yes.
Accordingly, she uploaded her choice of location in the relevant tab on so and so, along with her request application dated so and so, address to so and so, which was uploaded in the tab, seeking exemption from annual transfer 2026 for 1 year, or alternatively posting to CISF unit OPS Nunmati, copy enclosed. Subsequently, her posting has been issued to CISF unit SSBS Salakati under district Kokrajhar, which was her third choice. As per so and so, she had completed 7 years, 4 months in the out of home and 14 years, 9 months in the home sector.
This
And
is your third choice. They have rightly said that you've given the transfer posting as per choice. What else
There
do you
is a
want?
mandatory field, one personnel has to fill it up at least 10 choices. So that is a mandatory field.
Your submission
far-
before the court is that you have been transferred to Kokrajhar, which was not your choice.
Yes,
the
my
authorities-
personal was.
Authorities have stated in their
Yes,
order that this is as per choice.
as per that is a third
all
choice they
the
have
first,
stated.
first choice is not possible, Lordship. We have to see other situation also.
Yes. We dismiss, so you withdraw. Friday, think about it.
Yes.
Based on Friday.
What next?
Mail. Your Lordship, the petitioner is agreed by the impugned order at page 41 to 44, Annexure 6,
44.
41 to 44.
dated 25th November 2025. In this impugned order, the petitioner has been imposed a minor penalty of deduction of his monthly salary for the period of 6 months. Against this impugned order and prior to the imposition of this minor penalty, the petitioner has been communicating his grievance to the respondents and has been seeking documents. Against this speaking order, there lies an
Did you
appeal.
file an appeal?
Yes, I want to file an appeal, but I have not been provided any documents.
Where is your application seeking documents?
Your Honor, Annexure 7, 45 to 65. Page. (27/11, 2025). Annexure 7.
Who's the appellate authority?
The appellate authority is
Who represents Mr. Medi?
the Rule 24 provides for an appellate authority under the CCS Classification Control and Appeal Rules 1960.
You get instructions on this page 45.
Yes.
He's asking for some documents which according to him has not been forwarded. As a consequence thereof, he could not file his appeal. Please get it by next Wednesday. Or when?
Madam. 26.
25th.
Your Honor, that will be too far because Your Honor, my issue is
21st. Let it be 20.
20.
Yes, 20. Give him an extra copy today.
Yes.
Petitioner is agreed by the fact that
Meantime, Your Honor, the operations of the impeached order
No,
may
no,
be
no.
stayed.
No. The petitioner is agreed that by the order dated 25/11/2025 passed by the Controller General of Accounts ad hoc disciplinary authority, whereby a punishment for reduction, minor penalty or reduction to lower stage at the time scale by so and so in page 43 was imposed. Stop petitioner is desirous of preferring an appeal, statutory appeal. However, certain documents which he claims to have sought for during the inquiry proceedings have not been furnished. Stop, he filed a fresh representation before the authorities on 27/11/2025 seeking those documents, which till date has not been furnished. Being agreed, the petitioner is before this court. Whereas Mr. S.K. Medi, learner CGC, submits that he would like to complete his instructions on his representation and the documents he has sought for, and as to whether the said documents have been furnished. We'll have it on 22nd. Let the matter be listed on 22nd by which date?
22nd.
All right, 20. On which date the CGC will apprise the court in order to enable the CGC to obtain instructions or, although notices are not issued at this stage, extra copies be furnished within the course of the day. List accordingly.
Next.
Yes, Mr. Goswami.
To the Lordships.
Yes.
Lordship, this matter was heard last week. The
Yes.
state was to take, the issue was that about extension of the benefit of the rate appeal judgment.
We wanted you to apprise us as to why you did not prefer an
Yes,
appeal or
yes,
why
yes,
you
I
can't
had to
prefer an appeal now.
Yes, yes, that is what. Lordship, I had to apprise Lordships about the query that Lordships had asked last time. Now, first, Lordships, take Lordships to the judgment. I will address the query on three grounds. Why? Would first Lordships kindly take the writ appeal judgment, which we are seeking for extension to us also? What does the appeal judgment say? What exactly? Because the directions may say something, but let us see what the appellate judgment actually meant. Would kind Lordships have page para 46, page 348 of the appellate court judgment? I will just read a few paragraphs to explain to the court what a division bench judgment actually means and how it is applicable to us. Para 46, may I place it, Lordships? Page
Yes.
348.
Yes. Yes.
Yes. The fulcrum of the state's argument is that the appointments of the appellants are rendered void ab initio on account of the infraction of Rules 1997 framed under the proviso to Article 309 of the Constitution of India. According to the state, the Joint Director of Health Services lacked the authority to initiate recruitment, advertise vacancies, constitute the selection committee, and issue appointment orders, all such powers being vested exclusively with the Director of Health Services, Assam. This is the basis of the state's case. Now, let us see how the division benches dealt with it. Please kindly come to page 353, para 65 onwards. Because this would cover everyone in that selection process, is what I'm trying to emphasize. The findings. Page 353, para 65.
Hmm.
May I place it, Lordships?
Yes.
In the present case, the appellants did not enter into service through a
So
concealed or
we
surreptitious
just want to know one thing. This appeal
Yes.
was rendered in an appeal which was preferred by a set of petitioners, right? Being aggrieved with a judgment passed by coordinate bench.
Lordships.
Now, is it a case that this is the first time you have approached this court and you want the benefit of the judgment, or
We are saying, I appreciate what is following. We are saying the single judgment has merged into the division bench judgment.
that
So
interpretation,
therefore, today the doctrine of
that interpretation, you get it from the division bench.
Pardon, Lordships?
You have this particular division bench judgment is rendered setting aside the judgment of the single bench vis-a-vis the appellants.
No, that is what we are trying to say. No. That is what we are saying. It is a judgment in rem. That is what we are trying to emphasize. If you are commenting on the process, that is why I wanted your Lordships to go through those paragraphs. Was it the High Court? That is, and therefore I'll place another judgment, Adesh Srivastava, specifically on this point. But if Lordships may permit me to read this paragraph, then we can
So
demonstrate
instead
that
of
these
going
are
into
fine.
this, interpretations, what we find it difficult to understand or appreciate is what stops you from going to the appellate court and saying that, look here, this judgment has already been set aside. We are also similarly situated persons. We want a similar judgment. That would set at rest all controversies.
Then Lordships may give us the liberty.
You don't need a
Kindly give us
liberty.
the liberty.
You don't need that
Because,
liberty.
So we may, because once we have preferred, because ultimately what is it? We have come against non-disposal of our representation that we have submitted to the government. That is our cause of action.
No, the
We submitted a
government cannot override a judgment of a court, notwithstanding the judgment has been turned down in an appeal preferred by similarly situated persons. So far as you are concerned, Perhaps
what
the
we were-
understanding of the government is that there is a judgment against you and you have not gone in appeal.
That is what we are trying to dispel through the court.
So, but you are asking
That
us to interpret
our-
coordinate bench judgment.
No, we are not. We are just saying that
The effect of interpretation,
against anyone that single.
I don't know, the effect of interpretation that this judgment is
Today what
appellate
we are-
judgment is a judgment in rem and will override or merge the judgment of the single bench will require interpretation by a coordinate bench.
No, because what we are trying to say is that if there is a merger. There is a merger of the single bench today. As on today, the single bench judgment doesn't exist for the simple reason. Para 12 of Kunyamet already says that for one subject matter, there cannot be two conflicting decrees. That is why the
Exactly.
doctrine of merger comes in.
No, that is quite right. But the merger will
There cannot be
come.
two
Merger will come when the procedure laid down will have to be followed, subject to correction. There is an appeal. There is a common judgment against which some of the parties to the judgment preferred an appeal, and they have the benefit of the appellate court's order overturning the judgment of the single bench. Will it amount to a merger so far as the other litigants are concerned?
Yes, it would. Yes, it would. That is my full submission. Because on one subject matter, there cannot be two conflicting orders. It cannot be that the process is correct vis-a-vis you,
But
but the
that-
process is bad in your vis-a-vis
That's all right.
others.
But the question is, what stops you from going to the appellate court and getting an order? That
Your Lordship,
is without entering
I
into any controversy.
bow down to your Lordship's suggestion. I bow down. I bow down.
It's not
I
a
bow
suggestion,
down.
just a query going on in my mind, which we are asking that when you have an order passed in a judgment, common judgment, in a writ appeal preferred by similarly situated persons,
I totally agree to what Lordship is saying. I totally agree. It is just that we thought that the spirit of Order 41 Rule 4 would apply. Though the CPC doesn't apply, but Order 41, if Lordship sees Rule 4, anyway, the reversal can be at the behest of anyone.
yes, Mr. Gogoi, what do you say?
Lordship will see para 93 of the judgment, page 360.
Huh?
Page 90, para 93 of the judgment. Finally, whether it is a order passed in rem or in person, Lordship will see that point. Whether the relief has been granted to the appellant or in general merit judgment. Para 93.
That's what we are saying. It
Yes,
requires
my lord, how
interpretation.
when a coordinate bench says, my lord, upheld, my lord, dismiss their petitions, whether now this honorable court, my lord, can re-examine that part, and my lord, now upheld their, my lord, termination in the single.
You see, you come to para 93, Mr. Goswami.
Yes, yes, Lordship, para 93.
The appeals are allowed, judgment is interfered with, but the termination order against the appellants are quashed.
That is a consequential direction to the previous paragraphs. A paragraph cannot be read in isolation. That is one. You have Lordship, obviously, when the final order of quashing comes, it will be qua the appellants. Because they were the people there.
CPC.
This is the consequential direction to the previous observations that the whole process is bad. Mr. Gogoi was there itself. He was opposing us there before a division bench. When the whole process has been commented to be bad, it's bad.
Yeah, you're referring to order 41.
Rule 4.
Hmm.
It's in the spirit of that. Though I know CPC may not be strictly applicable, but the court obviously often goes to there. What is important is the expression common ground.
Yes, but this is not what this paragraph ultimately says.
Para 92 and 91 may also be read if Lordship will have to, if I have to explain para 93, then para 91 and 92 will also have to be read. Para 93 cannot be read in isolation. Para 91 and 92 describe the whole process to be bad.
No, 93 does say that the judgment has been interfered with.
Yes, so judgment will be interfered with. Therefore, no, therefore, Lordships now is the issue which now is grappling is whether we can extend this benefit. For that, I would like to place one authority of the Supreme Court. That in such a
Yes.
situation, what happens? And that is the authority that is followed till today.
Yes.
If I may place that, Lordships, Arvind Kumar Srivastav. My colleague may hand over, Lordships.
Addition to one.
Arvind Kumar Srivastav, 2015, 1 SCC 347.
But para 93,
Yes, Lordships.
this is the problem. You see, the judgment of the court, if it requires an interpretation, it becomes difficult. Statute's all right. But the judgment of the court says, on one hand, the judgment is interfered with. The appeals are allowed. Judgment is interfered with. But termination orders issued only against the appellants are quashed. Now, so therefore, does it mean, because if we are to read your interpretation that the notwithstanding only some of the petitioners as appellants had challenged this the single judge's order, the court is not powerless to interfere with the judgment, we accept that. But if the judgment was indeed interfered with, perhaps the consequential order would be that all termination orders ought to have been set aside, including yours. But this is not what is said.
So therefore, Lordships, this judgment may be of some help, Srivastav judgment. May I just place it?
Yes, yes.
Yes. Kindly have a look at para 2 of the judgment. What was the issue?
Para?
At page 350, para 2. What was the issue before the court? Para 2. May I place it?
Yes.
To mention at the outset, the tribunal as well as the High Court has given the respondents herein benefit of the order passed by the court in an earlier round of litigation filed by similarly situated persons. The appellants contend that as far as these respondents are concerned, they never approached the court seeking such relief and were only fence-sitters, and therefore relief should not have been granted to them even if they were similarly situated as those persons who have been granted relief in the petitions filed by them. The respondents, on the other hand, contend that once it is found that both sets of persons are identically placed, the impugn orders granting them the same benefit are in tune with the constitutional mandate enshrined in Article 14 of the Constitution of India. Now, please see how the court has answered this at para 22. That was the issue before the court, and Lordship will come to page 363 of the judgment, para 22. And this is a judgment followed till today.
Yes.
The legal, may I place para 22, Lordships? The legal principles which emerge from reading of the aforesaid judgments cited both by the appellants as well as the respondents can be summed up as under. 22.1. The normal rule is that when a particular set of employees is given relief by the court, all other identically situated persons need not be treated alike by extending the same benefit. Not doing so would amount to discrimination and would be violative of Article 14 of the Constitution of India. This principle needs to be applied in service matters more emphatically, as the service jurisprudence evolved by this court from time to time postulates that all similarly situated persons should be treated similarly. Therefore, the normal rule would be that merely because other similarly situated persons did not approach the court earlier, they are not to be treated differently. 22.2. However, this principle is subject to well-recognized exceptions in the form of laches and delays as well as acquiescence. Those persons who did not challenge the wrongful action in their cases and acquiesced into the same and woke up after long delay only because of the reason that the counterparts who had approached the court earlier in time succeeded in their efforts, then such employees cannot claim that benefit of the judgment rendered in the case of similarly situated persons be extended to them. They would be treated as fence sitters, and laches and delays and or the acquiescence would be valid ground to dismiss their claim. 22.3. However, this exception may not apply in those cases where the judgment pronounced by the court was a judgment in rem with intention to give benefit to all similarly situated persons, whether they approach the court or not. With such a pronouncement, the obligation is cast upon the authorities to itself extend the benefit thereof to all similarly situated persons. Such a situation can occur when the subject matter of the decision touches upon policy matters like scheme of regularization and like. On the other hand, if the judgment of the court was in personam, holding that benefit of the said judgment shall accrue to the parties before the court, and such intention is stated expressly in the judgment, or it can be impliedly found from the tenor and language of the judgment, those who want to get the benefit of the said judgment extended to them shall have to satisfy that their petition doesn't suffer from either laches or delay or acquiescence. This is the legal position, Lordships.
So here, that is the first query, that why you did not come at the opportune time before the court. Your interpretation that this is a judgment in rem is all right, but that para 93, although it interferes with the judgment, but the consequential orders are only in respect of the appellants.
Oh, I appreciate. Therefore, the consequential orders could be in respect of the appellants. Once Lordship says the benefit goes to us, then the consequential orders will be passed by the state. We are just wanting the extension
it can't be passed by the state, the consequential orders, because there has to be some finding by a court of law that this is a judgment in rem, and therefore, since the judgment has been interfered with, the consequential benefits are to be given. It amounts to interpretation of a judgment of a division bench, when the option of going and filing an appeal before the division bench is quite open for you. All right, we'll issue notice, let them obtain their instructions and apprise the court.
Keep the issue of maintainable is open.
You have to apprise the court in the respect of the judgment placed by the petitioners. And tell us that it is not applicable. But one thing is certain, that the judgment has been interfered with. You cannot interfere a judgment only in respect of a set of petitioners, especially with this finding of the division bench.
No, my lord, in the entire batch of it, we are preferring SLP against the judgment, my lord. This will be looked into by the Honorable Apex Court. But my lord, in this particular batch, my lord, not only it was limited to this particular two districts, my lord. There are other districts, my lord. The facts were different, my lord. That's why, my lord, Lordship will see the judgment, my lord. In every case, my lord, the facts have been narrated and all has been dealt with. It cannot be that, my lord, one go, entire judgment goes and all will have to be reinstated.
This is what the judgment says.
No, but, my lord, the relief has been given only to the appellants, my lord.
That's a different issue, but the judgment has been interfered with.
It will be limited to those, my lord.
That is an interpretation you are giving.
Same, my lord.
Which is not there in the order.
No, my lord, the next line very The very next line says so,
Yes.
93. Says that, my lord, the so and so will be reinstated.
That's right, but it doesn't say that the judgment insofar as the appellants have been interfered with.
Well,
The order of the division bench is that the judgment is interfered with.
my lord.
So we'll have to read that the judgment has been interfered with.
Interfered
Whether
with to the
consequential
extent-
benefits are given to the appellants or to all is a different issue.
My lord, without a consequential, my lord, effect, whether a judgment can be, my lord, complied with.
No, compliance is a different issue. We are on
Because, my
whether
lord,
the,
moment, my lord, the.
you read the
No, I
findings
have
of the
read it,
division
my
bench.
lord. I have read it, my lord.
Division bench
But I-
judgment is clear that
No, by
common-
the second line, it has been made clear that, my lord, it is limited to the writ appellants only, my lord.
no, that is not the wording of the judgment. That's what we are saying. That will be an interpretation of the judgment.
Might be, my lord, that if there was a wrong impression that, my lord, these are the, my lord, writ petitioners who have preferred, my lord, the appeal. Only they are limited to them, my lord. That will be clarified in that case, my lord, file a, my lord, clarification.
You may file a clarification
Of course, my
petition.
lord.
That's
If
a
that
different
is
issue.
the argument they are making.
Lordships.
But, my lord, one thing they will have to point
State
out,
is
my lord, the
taking-
judgment was
today
passed in
the-
2023.
That option you have.
Whether they can, my lord,
They are fence sitters.
they
they
have
have
felt
come
it up, my
late,
lord. All
etc.,
along
etc., these are there.
they took a chance. Now they are coming up. That too before the learned single judge, single bench, and they want a order that, my lord.
Because the judgment says it is interfered with.
That, my lord, they will have to, my lord, pursue before the division bench.
Yes.
In fact, today the state is taking is completely opposite party to say.
We'll hear them.
Definitely.
That
Party
Mr.
to
M.
consulted.
We'll issue notice today. Mr. M. Goswami, Senior Counsel, assisted by Mr. R. Sinha, appears for the writ petitioner. The petitioners are aggrieved that notwithstanding that the petitioners you were serving as what?
With grade 4 lordships.
They were, man.
They were grade 4 employees
Yes,
under the
lordship.
health department in a
Gwalpara,
particular district.
Dibrugarh.
In the
Dibrugarh
district
and
of
Gwalpara.
Dibrugarh and
Gwalpara.
all right, item 13, Dibrugarh, 14 is in Gauhati. The petitioners stood terminated by the department, and which termination was essayed before the court in a series of writ petition. The writ petitions filed before the division bench, before the single bench. Where is the judgment?
Lordships,
Single bench
judgment. Single bench judgment is
Huh?
not on. It is page 205. Page
205.
205, annexure 15, lordships.
So which is your writ petition? WPC 1931 and WPC? That is Dibrugarh.
Yes.
1931 of 2019, 2020 and 8220 of 2019. This is Gauhati. All these writ petitions, along with other bunches of writ petitions, came to be taken up for hearing, and by judgment and order dated 29/9/2023, the judgments, the writ petitions came to be. Is it dismissed?
Yes,
Says disposed of.
my lord, the terminations were upheld.
The terminations were
Terminations were
upheld.
upheld.
The terminations were upheld. Stop. Being agreed, a set of the petitioners before the single bench preferred an appeal, being writ appeal number 428 of 2023, which came to be decided by judgment and order dated 3001 2026, whereby the judgment and order passed by whereby the appeals were allowed, and the common judgment and order dated 29/9/2023 passed by the learned single judge came to be interfered with, and the termination orders issued against the appellants before the division bench are quashed. So there are the present writ petitioners, although had preferred a writ petition before the coordinate bench and which came to be dismissed by the common judgment and order dated 29/9/2023, passed in their respective writ petitions, did not file an appeal. Stop. The learned senior counsel, appearing for the writ petitioners, submits that in terms of the spirit of Order 41 of the CPC, where the common judgment and order passed by the coordinate bench stood interfered with, there was no need for the present writ petitioners to file a separate appeal and seek separate orders. Stop. The judgment passed by the division bench is a judgment in rem, as the judgment and order dated so and so passed by the coordinate bench stood interfered with. Stop. Only the consequential benefits thereto were limited to the appellants before the division bench. Stop. Since the judgment stood set aside and it is a judgment in rem, the petitioners filed their representation before the Joint Director, Health Services, Dibrugarh, ventilating their grievances, seeking appropriate orders for permitting them to join in their respective posts and be granted all service benefits. Stop. These representations having remained unattended, the present writ petition has been filed. Mr. M. Goswami, Senior Counsel, referring to Order 41 of the CPC, submits that although CPC is not strictly applicable, the spirit thereof is, and where some of the aggrieved persons prefer an appeal, court is not powerless to pass an order interfering with the entire judgment or the decree, as the case may be. In support of his contentions, he has pressed into service the judgment of the Apex Court rendered in State of UP versus Arvind Kumar Srivastav, reported in so and so. He submits that this is an authority to the fact that where a particular set of employees is given a relief by the court, all other identical situated persons are required to be treated alike by extending their benefit, and not doing so would amount to discrimination and would be violative of Article 14 of the Constitution of India. Stop. This principle needs to be applied more emphatically in service matters, as service jurisprudence has been evolved by the courts of India from time to time. Stop. He therefore submits that where the division bench, by the judgment and order dated so and so, has categorically interfered with the judgment and order dated so and so passed by the coordinate bench, there is no need for the petitioners to separately file appeals and seek interference of a judgment and order which has already been interfered by the division bench in a writ appeal preferred by similarly situated persons. He therefore submits that the appropriate directions be issued by the court, directing the respondent authorities to reinstate the petitioners back in service with all service benefits as permissible under law. And in terms of the judgment and order dated so and so, passed in writ appeal number so and so. Per contra, Mr. B. Gauhati, additional AG, appearing for the state, strongly objects to the submissions made. He submits that the petitioners are nothing but fence sitters. Their judgment and order by the single bench was rendered on so and so. This judgment was a common judgment where a bunch of writ petitions, including the writ petitions preferred by the present writ petitioners, have been taken up for hearing and disposal. Stop. While other similarly situated persons had approached the appellate court seeking redressal of their grievances. The present writ petitioners did not choose to prefer any appeal stop. He disputes the interpretation sought to be given by the counsel for the petitioner that the judgment rendered by the division bench by the judgment and order dated so and so is a judgment in rem. Referring to para 93 of the judgment, he submits that the bare perusal of the said paragraph makes it clear that it is only the appeals preferred by the appellants before the division bench are allowed and their termination orders are quashed, and therefore the judgment and order dated 29/9/2023 passed by the learned single judge has to be, although has been interfered, has to be limited only to the benefits thereof should be limited only to the appellants before the appellate court and not to the present writ petitioners as sought to be interpreted. He therefore submits that he therefore questions the maintainability of the present writ petition in the present form. Having considered the submissions made by the counsel for the parties and upon perusal of the judgment of the division bench rendered in writ appeal number so and so, as also upon perusal of the judgment pressed into service rendered in Arvind Kumar Srivastav Supra, this court is of the view that the matter will require consideration on these aspects. Therefore, let notice issue returnable for weeks. Mr. B. Gogoi represents all the respondents. Therefore, notices are waived. Extra copies will be furnished within a period of 1 week from today. Matter be listed after the returnable date. Since the question of maintainability has been raised by the respondents, the same shall be considered on the next returnable date. List accordingly. Yes, Mr. Goswami.
Lordship, wherever Lordship has put order 41, Lordship is order 41, rule 4.
Rule 4, yeah. Order 41, rule 4.
Rule 4. I'm
Yes.
very grateful, Lordships. Very grateful.
This item 13 is Dibrugarh, 14 is Gwalpara. Is that correct?
Yes.
Right.
Yes, Lordship.
Yes.
Grateful, Lordship.
My lord, respondent number 6 has filed an additional affidavit. I missed the copy. Can you? My lord, respondent number 6 has filed an additional affidavit. I need to go through and file my reply. I pay for 2 weeks time to file my reply.
This is item 26.
Item 26.
Counsel for the petitioner submits that an affidavit has been served on them by the respondent number 6.
Number 6.
He therefore prays for 2 weeks' time to complete his instructions thereof. Prayer made is allowed. List this matter again after 2 weeks.
I am for 10 and 11.
MS MD Bora appears for respondent 10 and 11. Mr. B. Chaudhary for SLRC MSS Bora for 1 and 2. Mr. D. Upamanyu for health.
I am also respondent number 9 is not
Heard counsel for parties issue notice returnable 3 weeks. Steps on. You are there, MSS Borwa. He accepts notice on behalf of all.
Central Government.
That's for last one.
1, 2, 3, 4, 5. No, sorry. 1, 2, 3, 5.
That's for last one. R maybe CPS 6 years for all the 1 to 8.
No, in the IA. You appear for 1 to 8. And who's for state? Mr. J.K. Goswami appears for respondent 9. Since the respondent opposite parties are duly represented, notices are waived, extra copies furnished within 3 working days. Respondents will apprise the court. Respondents may file their objections, if any, list after the returnable date. After returnable date.
On the last occasion, I'm receiving the salary.
You are receiving the salary. What is the IA for?
I was, the order was passed to stop my.
Stop your
Stop, my name was stuck off here.
strap off. So what prayers you want in the IA?
The I paid this particular order in the page 28. Order with a 20. My ID.
IA will go. In the IA, the prayer is made for stay of the order dated 20
Yes.
02/2026, whereby the competent authority had directed striking off the name of the petitioner from the strength of the composite hospital with effect from 25 to 2026. So petitioner is putting a challenge to paradigm. Petitioner is challenging the order, impugned order passed by the competent authority. Directing compulsory retirement of the writ petitioner. So the said order is being assailed in the accompanying writ petition, being WPC 7011. Stop.
I'm already in the entry.
By which order? By which order? Hmm? Then said you are under interim protection.
Yes, sir.
We can't find it here, therefore we are asking you.
In the I.
In the IA. By order dated 25 to 2026, the order striking off the name of the petitioner from the strength of the composite hospital was directed to be not given effect to. The same interim order still subsists. What about the respondents? Have the pleadings exchanged?
This matter, our Devi will appear since he is out of station today. Therefore,
Your pleadings are exchanged in the writ petition.
Yes.
Since the pleadings are exchanged in the writ petition, the matter be listed for admission along with the I. So interim order passed in the I will continue until further orders.
okay.
আজি এটা 15 বহিম দেই 3টা বজাত মোৰ টিভি আছে সেইকাৰণে এটা 15 বহিম ইমান করতে পারে মাটি তাৰপিছত আকৌ মোৰ কমিশ্যন যাব ইয়েছ
Matter related to communication personal law. Can fill the last order.
Yes, Panchayat, any instructions here? We had recorded your name.
I will submit the minute. That is the officer from the
Who has submitted this?
provider that I have submitted.
Who is for director pension?
Pension, see, last occasion I have submitted the instruction that the medical report was not proper format. Therefore,
And now they appears to have,
they submitted it before the executive officer and they have to send it to the pension.
they have by this letter. You give her a copy? You give her a photocopy of this. In deference to the earlier order dated 6/4/2026, it is submitted by the counsel for the petitioner that the medical documents are against of Sri Bhavendra Brahma. Huh? Bhavendra Brahma has been submitted before the Chief Executive Officer, Bongaigaon Zilla Porishod, Bongaigaon, Command, and the same has been forwarded to the Director of Pension, Government of Assam, by communication dated 23rd of April 2026. So, a copy of this communication is placed before the court by the counsel for the petitioner. So, Para MS Borwa, Learned State Council, submits that she will complete her instructions of the status of the papers being submitted before the Director of Pension. Where accordingly, the matter be listed after 2 weeks. We permit the counsel for petitioner to furnish a copy of the communication to the State Council appearing for the Director of Pension. And you give us a photocopy also. Another photocopy rakibole.
Please, Your Lordship. Lordship, our affidavit is ready and we have sent it for vetting, Lordship. And it may be taken up next Friday, Lordship.
Next Friday, 22nd. All right, MSS Kemprai, Learned Council appearing for the petitioner, Autonomous Council, Karbi Anglong, submits that the affidavit will be filed within the next 3 working days, by the next week. And she therefore submits that the matter be listed on the next Friday, which is 22nd of May. Where Mr. S.K. Das appears for the petitioner. List again on 22nd, let's break for.
Obliged.
With 2 weeks, more time is required.
Mr. J.K. Goswami, additional senior government advocate, renews his prayer for further 2 weeks to file their affidavit in opposition. Mr. M.P. Chaudhary appears for the petitioner. List after 2 weeks. Interim order, if any, passed earlier, will continue.
Similar matters are also pending.
Let him file the affidavit first.
After 2 weeks. No. Director of
Affidavit filed?
Yes, Lordship. I am respondent number 5, Lordship. I have filed.
Respondent number 5, but respondent is not filed.
Who has not filed?
Respondent number 2.
Who is respondent to?
Director.
Director of Land Records. What is your grievance here?
Regarding
Gaunbura.
Yes.
So, who was appointed? Respondent 5.
Files.
You challenged, filed an appeal. What happened in the appeal?
It was
dismiss. Against that, did you file a revision? Review, revision?
Review, Lordship. Not pending.
You go and file that.
My lord, the
So far.
What is the
reservance
ground,
order, Lordship.
what is the ground for challenge in the, of the appellate order?
down, my lord, the condition that condition that, my lord, I am the son of the Gauhati, Mondadar, given the public. But when the only the receipt of the mark, my lord, only mark, my lord, pays, my lord, only half mark. That was given when the Mondadar commanded to appoint to me, but that part is not considered.
Where in the rules or the advertisement is it mentioned that
Yes, my lord.
these marks will be allotted in these heads?
My lord, the mark kindly, my lord, is 62. I got, my lord, 16 months average and, sorry, this one number 8 got 81 and I got, my lord, the 20.67, my lord. And in the years, my lord, the species, my lord, the count of the Mondadar.
Where under the rules is it provided
My lord, I can make.
that you are the son of the Mozadar?
Yes, my lord.
Ah. So preference will be given,
Given, my lord.
preference to be given only when the marks are same.
Yes, Lordship.
You have obtained lesser marks.
My lord, no. On the particular, my lord, the regarding the Mondadar view, that is not considered all, my in my meeting.
You are referring to page 23, clause 12. Come to page 23.
Yes, ma'am.
See clause 12.
My lord, here the preference is given to the member of the village, the Gaura, the headman, and the opinion of consider in this regard. But yes, my lord, that is not considered in my case.
What is not considered?
My lord, the regarding the I am the son of the Gaura, that part, and regarding the other part, other part is not protected in part.
No. You are to be given a preference.
But
If you are the son of the, if you belong to the family of the headman.
headman and Mozadar also.
Ah.
Mozadar, recommendation of the Mozadar, that part also consider.
Right. That part will be, that is to be considered as a preference. Preference
Mozadar
will.
part is not different, man.
Huh?
Mozadar part is not different.
So opinion will be considered opinion of the so and so in this regard.
My lord, regarding the mark for the Mozadar, there is small, that is similar, that part is not mentioned.
No. It is only the opinion of the Mozadar in this regard. Which regard? Regard of giving a preference.
Different, my lord. So my case is, my lord, the part of Mozadar part, my lord.
It does not affect you because you have obtained lesser marks.
My lord, mark is
If you had obtained same marks.
In this regard, I realize, my lord,
Yes.
Mark. I come, my lord, from husband of Lord Rajeshwar Das, the revision, my lord. Here, my lord, the mark is considered that part.
Lordship, my objection is that this judgment is not applicable, Lordship. This judgment was passed prior to amendment, Lordship. Amendment has been come on 10/4/2018, Lordship.
What amendment?
Yes, Lordship. To the executive instruction, Lordship. Some amendment has come on 10 wide notification dated 10/4/2018, Lordship. And advertisement was made as per amended rule.
What is the amendment?
Yes, Lordship. Earlier, it was the law, Lordship. 3 factors shall be considered, Lordship. One is claim of the Kaura's family, one views of the Mozdar, and another is the Lordship, views of the local public, Lordship. But as per amendment, Lordship, preference shall be given to the family members of the Gabura, Lordship. And when question of preference will come, then, Lordship, Mozdar views will be considered, Lordship.
In this regard, I am referring on judgment, Lordship. It is clear from the judgment. Everything is discussed, Lordship. Lordship, para 16, Lordship, onwards, Lordship. Para 16, 17 and 18, Lordship, it will make it clear. May I read, Lordship? The Supreme Court as well as this court in a plethora of decisions which need not to be cited on, again had clearly held that the concept of giving preference to one candidate over the other comes into play only when the marks obtained by the two respective candidates are equal. If the marks obtained by the two candidates are unequal, in such circumstances, there is no requirement of giving preference to the candidate over the other, and the inequality of marks would be determined as to who amongst the two candidates would be selected. Then, Lordship, paragraph 18, Lordship, as regard to the other contention that the views of the Mosdar is a mandatory requirement under clause 162.15 of the executive instruction as amended from a reading of the said provision, it is discernible that preference is required to be given to a family members of the Gaura and views of the Mosdar shall be obtained. We have to take a note of that the provision of clause 162.15 is a conjunctive provision, Lordship, where the requirement of giving preference to the family members of the Gaura is in conjunction with the requirement of obtaining the view of the Mosdar through the expression and Lordship. So, Lordship, when the question of preference will come, when both the candidate will obtain equal marks, then views of the Mosdar will play a role. This is clear for me. Then, Lordship, paragraph 23, Lordship, bottom, Lordship. The unamended provision clearly provided that three distinct and independent factors to be taken into consideration for the appointment of Gaura. That is, claims of the family of the deceased Gaura, the wishes of the villagers, and views of the Mosdar. My friend is projecting his case under old law, Lordship, but as per new rule, Lordship, as per new law, Lordship, preference only. Preference only given to the family members. These three factors need not to be considered. Lordship.
No, under the old law also, preference is to be granted.
But under the old law, these three factors, Lordship. But even, Lordship, the selection committee has given 5 marks more to the petitioner, Lordship. Then also he is obtained.
How much marks did they obtain? Petitioner, respondent, what is the marks? What marks have you obtained?
Lordship, from
Huh?
62, Lordship.
So what marks?
Mark Miller, the respondent obtained 18 marks.
Where is it preferred? 18 marks.
18 marks.
Respondent 4.
And I obtained my lord 17.67.
That is
Only
after.
my lord 0.33 marks.
But, Lordship, the 5 marks was given as a preferential.
5 marks given to whom?
The son of the Gaura, petitioner, Lordship.
Ah.
Yes.
So he became 22.
No, Lordship. After adding 5 marks,
He gets 17.
yes.
Oh. Then what is your grievance?
Mark kindly, my lord, last week, my lord, the respondent number 4, that is my lord, the private respondent, she put the highest granted total mark average 18 marks. And compared to the appellant, that is the petitioner, 17.67 marks. Well, only 0.33 marks more than me. Here this case, my lord, when the 5 marks is equal to each column, my lord. Mosdar column, what mark is provided, my lord?
Where is the records? Where are the records?
Record is not.
Get the records
That
of
part,
selection.
Lordship, the Honorable Division Bench also decided, Lordship, on case, Lordship, only preference will be given when to candidate.
We'll examine Mr. Hande. Can you give us the records of selection?
Deputy Commissioner.
Deputy Commissioner, get the records of selection.
Selection.
Selection process, who got what marks under what head, let us see.
That's what my lord.
The petitioner and the respondents are private petitioner before this court assailing the order passed by the appellate authority, upholding the appeal, allowing the appeal preferred by the private respondent, and whereby the order of the deputy commissioner appointing the petitioner as the Gauhati was interfered with. Stop. The core issue between the parties is as to whether the preference as required to be granted by the authorities to the petitioner, as he is a member of the Gauhati family, was granted, and also whether the opinion of the Mozadar was considered. While the petitioner submits that this was not considered, and has pressed into service the judgment of division bench of this court rendered in Rajeshwar Das, reported in so and so. The respondent on the other end submits that the judgment of Rajeshwar Das is not applicable to the facts of the case, as the present selection and appointment is pursuant to the amendments carried out. He, however, presses into service a judgment by a coordinate bench rendered in Karimali, reported in so and so in support of his contention. So, after examining the judgment and the pleadings available before this court, it is seen that the records relevant for records pertaining to the selection of the petitioner and the respondent would be necessary for examination by the court. So, therefore, the learned State Council, MSS Burwa, is directed to produce the records of selection available with the office of the Deputy Commissioner, Nalbari, on the next date list. On when can you give it? 8th of June.
Worship maybe better, 10.
10th of June.
Okay.
35. Review medical, similar orders were passed by your lordship, that can be done, because I have not received the instructions, Lord,
Regarding?
Review medical.
What is the defect?
Defect was first penile vitiligo and high blood pressure.
Huh?
Penile vitiligo and high blood pressure. First 35 Rajesh Prasad.
Where is that RME?
RME
98.
98.
Typed copy at 97. No.
This is DME.
Okay.
97.
High blood pressure and what? Tachycardia.
Penile vitiligo.
That he's got high blood pressure
Lordship.
and tachycardia.
And review.
Now this is the review
This was detailed medical.
on detailed medical.
This was detailed.
Then he was placed before Tejpur.
Yes.
Tejpur said, But this is with, but what about blood pressure and tachycardia?
Not find anything.
Huh?
That was not fine. The review also. Also will come to page 101.
You are rejected on 3 grounds.
Gotcha.
One ground, the doctor of the civilian hospital says no problem. What about the other 2?
Other two also will come page 101. That is the review.
Huh.
Review is a review also. Only single review.
Hmm.
Other two are gone also.
Okay.
And subsequently they underwent another medical examination at AMC also. They also diagnosed case of vitiligo. Yes, it's stable and non-progressive. Very restriction perform.
Here, then why further review is necessary?
Further review, not necessary, but similar orders were passed. I have not received the instruction. I have communicated to them, but not received.
Where is the copy of that order? Any copy of the order?
Annex law.
I have any
Page 114, 110, 109.
Petitioner appeared in CAPF examination. He appeared in the PET and PST. However, in the detailed medical examination, he was found unfit on these 3 grounds, page number 98, 1, 2, 3. Subsequently, he was placed before, he was examined by a civilian doctor in the Tejpur Medical College Hospital, and by the opinion dated so and so, he is found to be fit for duties. Page number 100. There again, he was placed before the review medical board, where he was finally rejected on ground number 1, Prolotita is 102. So, in that view of the matter, there was no discussion or reference to the opinion of the civilian hospital, where there is a detailed opinion granted that even the petitioner is fit for assumption of his duties, for being appointed to his duties. Under such circumstances, use the conflicting medical opinion, matter will stand remanded. We'll examine, the review medical board will re-examine and constitute the board and opinion of civilian doctors of the appropriate discipline, if required, he also examine. And thereafter pass orders, and if he is found to be fit, he shall be appointed accordingly. Right?
Subsequent procedure, not appointed, subsequent.
Subsequent
Stage.
the procedures applicable, he will be subjected to the procedure applicable.
Okay.
35 disposed.
36 is, but here is swelling in
fine. Forearm.
Hmm?
Fine.
Hmm.
Yeah,
Page number
page number 138.
100.
yes.
Swelling
Swelling in
The line of the
veins.
in the forearm. But there is no opinion that Here also, he was found unfit by the detailed medical examination, page 100, on the grounds 1 and 2. Subsequently, review medical board considered is unfit, the ground number 1, page 102. However, his examination before the civilian hospital, the opinion was rendered otherwise. He was found to be fit, and the condition on which he was rejected was not considered to be a medical condition, rendering him unfit. Page 104. Rest of the order would say remain the same. Okay. This goes. Affidavit file, no affidavit.
Affidavit sent for vetting, Lordship.
NSS Borwa State Council submits that affidavit will be filed within a short date. She prays for further 2 weeks
Yes, Lordship.
time. Prayer made is not objected to. List the matter again after 2 weeks.
Okay.
May please, Lordship, further 3 weeks time will be required, Lordship.
3 weeks.
3 weeks, Lordship.
Mr. A. Chakraborty, State Council, renews its prayer for 3 weeks time. Council for the petitioner does not object to the prayer made. List after 3 weeks.
Obliged.
After 3 weeks, you renew your prayer after 3 weeks.
And we pass over the matter for timing DYSA legs in court number 1. Timing
What is this transfer?
transfer by 15. By
Time
timing of legs.
Some more time required, Lordship, to file it.
Further 2 weeks time is granted to MSS Borwa on a prayer for filing the affidavit. Mr. A.H.R. Chaudhary appears, A.H.M.R. Chaudhary appears for the petitioner. This matter after 2 weeks on 5th of June.
Lordship, I have.
The service on respondent 3 is awaited. Service on respondent 3 is awaited.
Lordship, as per last order, we will appear for respondent number 5, Lordship.
That is recorded. You are appearing for 3 also.
Yes. As we are under instruction, Lordship, Wakalat number also not filed. Further 4 weeks may be granted so that we can file our reply also.
Yes. MSS Musari, Learner Council, submits on instructions that she has been instructed to appear on behalf of respondent 2 to 5. However, she prays for 4 weeks time to complete all instructions and file necessary power, and also affidavit if so advised. Prayer made is not objected to by the council for the petitioner, at least after 4 weeks.
Highly obliged.
Yes.
I am appealing for item of last occasion, Mr. Gauhati taken time for filing a plea. But the state IA, that is IA number 719/2026 was dismissed by the division.
What IA?
Therefore, they have prepared an appeal against the order of WPC pass WPC number 713121. We have a similar whereby that order is.
Which order?
Order dated
You
5/10/23 in similar order by the duty task.
you want the benefit of Upendas.
Lordship, I would like to pray for similar order passing WPC number 71313.
That is Upendas only.
Minimum scale of pay.
All right, third, counsel for parties disposed. The same line, subject to verification. MS so and so appears for the accountant general. Disposed.
I am appealing for item number
47. Who's for 48? Sorry, 46. You are appearing for 46? Only 47.
only.
All right, 47 disposed of. 46 to be listed next week.
Also, an internal inquiry has been initiated by the department, Your Lordship. That yet to be concluded, Your Lordship. We are praying for 2 weeks more time.
Mr. Sinha? Mr. B. Sinha appears for the petitioner. Mr. D. B. Bordoloi. The Bordoloi appears, G. Bordoloi appears for the cooperation department. He submits that inquiry is instituted by whom?
By the Register of the Cooperative Society.
Register of Cooperative Societies in respect of
The missing file
the
of
missing file in the office
the ARCS.
of the ARCS. Let the report of the inquiry be placed before the court within 2 weeks. List again on 8th of May. 8th of June. 8th of June.
Public.
Deference to the order dated 6/4/2026, the prospective arbitrator, Justice A.M. Mudharwar, former judge of the Gauhati High Court, has submitted a written declaration as is mandated under Section 12(1) of the Arbitration and Conciliation Act by communication dated 27/4/2026. By the said communication, Justice Mudharwar has expressed no difficulty in acting as the sole arbitrator to decide the disputes and differences arising by and between the parties. Stop. Under such circumstances, the order dated the appointment of Justice A.M. Mudharwar, former judge of the Gauhati High Court, as the sole arbitrator is hereby confirmed. So, copy of this order the mark to the office of the Registrar Judicial for onward communication to Justice A.M. Buzar Burwa. Stop. Parties are also at liberty to place a copy of this order before the learned arbitrator appointed. The parties will appear before the arbitrator on
Lordship may fix 30th of May.
30 May, 30 May, Saturday,
Yes, Lord.
before the arbitrator appointed, disposed.
In fact, here the pleadings is completed. Can it be on the hearing day so that admission here is still can be concluded, Madam?
Mr. What do you say?
On the hearing day.
Hearing day. Second of June?
Madam.
No, third, no, then it will be 4th of June.
Earlier.
As agreed to by the parties, that the matter be listed on 4th of June for admission hearing, as it is submitted that the pleadings on record, pleadings have been exchanged by the parties. Attempt will be made to dispose of the matter on the next date of listing.
Last order, Madam.
So we'll take it up at 2 p.m. 2 p.m. Hard or item number, even item 53. Why is it not released?
As per the 3 years, Madam, why stay for 3 years?
Who is respondent for?
Who is the Madam,
Finance.
Finance Department?
Who is appearing for women and
I am appearing
child?
respondent number 7, Madam.
Finance says that the instructions were sought to be furnished. No intimation has been received from the administrative department.
Madam, in the child development project officer under Gauhati, he was transferred to BTC area. So he was retired instead of BTC area.
Who is for respondent 567? You are the administrative department. They have
Already sanctioned the amount.
sanctioned. Where is it? Where is the sanctioning order? Page number 51.
45.
45 already. Amount is sanctioned.
Yes, ma'am.
Now, who is required to make the payment?
From finance.
Who's for finance? Finance department.
Page 31, Lordship, can you see this amount was sanctioned? From the joint director comes BTC Kupraja.
Please, we call up again at 2 p.m. for the finance. Finance. Item 54. We'll call up again at 2 p.m. Yes.
Lordship of communication, your lordship, if your lordship will have the affidavit of the respondent number 4, your lordship.
Six. Yes.
Yes, your lordship. So there's a mention of a letter dated, if your lordship sees the first paragraph, there's a mention of a letter dated 5th August 2024, your lordship. So your lordship had inquired if the respondent number 4 has to, had asked the respondent number 4 to bring a copy of that.
So page 56, where is the mention of letter dated?
Minus 56.
Annexure, you're referring to the annexures.
Yes. Affidavit by the respondent number 4.
What is the date of the letter?
21/5/20.
Yes. This is to the principal by the senior accounts.
Custodian accounts general were asked to produce that communication.
Why? Why did we want you to produce? For what purpose?
Your lordship, because they're disputing that the petitioner had not given the application on 19 January 2024 and instead had given the application on 3rd June 2025. Which is why this is relevant, because this letter dated 21/5/2025 mentions another communication dated 5/8/2024, which shows that the petitioner had actually put in the application before 2025.
Yes, Accountant General, why are you taking so much of time to produce these letters? Huh? Well, get the instructions. Get it by Monday. List on 18th. Enabling the learned counsel appearing for the Accountant General to produce copies of the produce a copy of the letter dated 5/8/2024, referred to in its communication dated 21/5/2025, Annexure B, to the affidavit. Filed on behalf of respondent number 4. Said communication would be necessary to examine the claim of the petitioner that she had submitted her application well within time, which however was not processed, and as a consequence thereof, there was a delay in releasing her payments. List on 18th.
Letter release temporary benefit. But the amount has not been issued by the treasury. Kindly change the order dated 6/4/2023.
Yes, finance. Yes, Mr. Cholia.
I have just produced the communication. Lordship, here what has happened, the services of the petitioner from new pension, it has been converted to old pension. Now certain contributions were made from the old, because of the old pension scheme, that is the government share and the petitioner share. Now because that amount has to be refunded, I have sought for the instruction, Lordship, the instructions are there. Once that amount has to be, they have already initiated the process of refunding the amount, the shares that was contributed. And that will be, once the refund is made back, the pension will be given. But for that, Lordship, some time will be required. This instruction is regarding item number 59, which is similar. Lordship, 58 and 59 are similar.
Yeah, how long will the process take?
No, Lordship, this has come to the knowledge, Lordship. Here only now, only the refund part is there. Department is asking for 3 weeks time. Once the refund process is finished, Lordship.
Why the refund is, how does the refund affect the claim of the writ petition?
No, Lordship, because now they will be governed by the old pension scheme. So earlier they had received certain amounts from the new pension scheme. So now the
So they
entire
are required to refund it back.
that will be done by the department, Lordship, Director of Accounts and Treasury. That will be done. Like there were certain contributions made, Lordship. So once I've been informed, once the recovery is made, all the refund has been put to the government part will go to the
That's
government.
very uncertain. You have to give a tentative date.
Lordship, they are saying they have within 3 weeks time they will resolve and the petitioner will get the pension. That is what I have been informed.
Yes.
It will be resolved, Lordship. Lordship may fix it any date after 3 weeks, Lordship. On that day, I will present the up-to-date status, Lordship. Most probably, it will be done.
Mr. H. Alia, Standing Counsel Finance, submits that the decision is taken by the department in favor of the writ petitioner that she would be, he or she, he would be covered by the old pension rules. However, since the petitioner was initially placed under the new pension rules, certain contributions were made by the state, which are now required to be refunded by the state, by the treasury, and the process is underway. Submits that once the process is complete, the petitioner's pension will be regularized. He submits that the 3 weeks further time be granted, by which time the petitioner, the counsel for the respondent will apprise the court with regard to the steps undertaken.
I've been
List on 12th of June.
Similar matter.
58, 59, 12.
59, I am praising. 59.
Mr. S.K. Medi for item 59. Mr. B. Chakraborty for 58.
Some order has been passed. 47 was disposed of. Similar matter, 46 also can be disposed of. Similar matter. I'm abandoning my prayer for regularization because I just pray for minimum pay. Can I pay for 6 weeks? After 1 month? Come on. 20. 20. Okay.
Here, husband and wife have been transferred. That, as per the policy, Lordship, can be placed where they have been posted at Jalandhar and
Jalandhar and Lucknow.
Jalandhar and Lucknow. My instruction is not that is an overnight journey.
Jalandhar to Lucknow.
That is my instruction. The couple posting regulations, Lordship,
Where is the regulation?
I am giving it. I have flag marked that.
overnight journey.
Not more than.
Jalandhar and Lucknow.
So far as my inspection goes, I don't have your notice. Traction on that. But you know, say the for both whether you know my medical condition, you know, I have annexed everything. There is a paper in my insurance, you know. That's the issue, and I am undergoing treatment in downtown, and will ultimately have to remove the insurance, you know. And there is a possibility, but in the
Then you can update.
no, that has been going on. You know.
Are you hospitalized?
So I have annexed everything. Your lordship can kindly come to page 29A. It's undergoing, I am treatment at downtown. That's why the problem. So far as the wife is
Your
concerned.
undergoing treatment means what? It, uh, in-house treatment.
No, not. Your lordship.
Eh?
I need a major surgery. Your lordship will kindly come to page 29. Your lordship.
Surgeon, let there be a medical opinion that you're traveling this, that, or you present yourself before the composite hospital, they will examine give a report.
Your lordship, that has been going on. I have annexed everything. Your lordship.
There is no compulsion work. And you are not being posted in the from your post.
Lordship, that is why your lordship, when I have made a prayer, your lordship.
You are going in medical, supposing you are in the hospital.
Your lordship will kindly come to page 30 for a moment.
30.
30. That's the composite hospital, your lordship. We have 9 9, your lordship.
Let there be an opinion that your presence in Gauhati is necessary for this treatment.
Lordship. That they can
Let that opinion be, or that they are transferred out. Come to page 30.
I have seen option.
There are some medical terms which are used. Now, this is life threatening. Whether this requires constant medical care is something that has to be concerned for me.
That can be applicable.
Yes.
Yes, will definitely.
First, because you see, if it is a consistent
Motion.
medical view required,
Yes.
then perhaps the husband's presence may also be required.
In that case, why? If there is anything like that, definitely.
Lordship, I would.
And then give us a report.
CRPF 9 9.
But stay there,
Jalandhar.
Jalandhar, state of Punjab, and the petition number. Stay there,
No.
Lucknow.
Still, 6 year and 1.5 year.
They're asking whether 18
Yes.
20,
No, no, no.
25.
Here, I have been telephonically instructed by the department. Lordship, since the matter relates to 2015-16, the record was not traceable. Somehow they have managed a few of the documents. They are in the process of giving the necessary instruction. Lordship may take it up after a week.
That we had not received any proposal regarding, because the petitioner was employed by the authorities in the BTC. And we had written a letter to the Under Secretary, Women and Child Development Department asking for some clarification. That was the situation. And Honorable Court had directed all the respondents to file the affidavit to clarify their stand. Because some sanctions were there, Lordship, but they were not specific.
Can you see the page number 31? It's the sanction order by the BBC.
Yes, but
Any amount of sanction.
yes,
Sanction.
This amount DCRG, GIS, and live encashment. These are the sanctions.
What else we want?
We have no release.
now he's claiming that this amount has not been paid.
Ah.
And Lordship, here these sanction orders are of the year 24. And till date, if they have not been paid, Lordship, a fresh sanction order has to be released by the authority. I had communicated to the department also. Lordship, these letters were never received by the treasury officer. So this has to go through the proper channel. It's written to the AG, marked to the AG also, Lordship.
Paragraph?
Page 34, Lordship.
24.
34 and 33, Lordship. 33 and 34.
That's the treasury of.
Lordship, the copy has been sent to the AG also. And Lordship will see Treasury Officer Dubri. And then again Treasury Officer Dubri, Lordship. But those have to be forwarded to the AG. The channel will be to the AG, then to the Treasury Officer. But the Lordship, no, the sanction has, then Lordship, this, why have they written to
Why
the
don't
AG?
you get an instruction from the treasury? Why are they not releasing it?
Yes.
What is the instruction?
Lordship, here on the last date,
Firstly, whether they have received or not the document.
they have not received it, Lordship.
Is there, I have instructions.
No, Lordship, I do not have written.
Get your instruction.
Lordship,
Why
that
are
I
you
can.
presuming? Which treasury is it?
Lordship, that is
Dubri
the
or Kubra?
no, that is the problem, Lordship. The petitioner had shifted to Gosaigaon also. So that clarification regarding where the petitioner will be drawing the salary from.
The BTC, where have you sent it? Dubri. Now, what is Dubri done?
All the salary were released by the treasury member, and thereafter she was transferred to Gosaigaon.
Yes.
In the meantime, the authority said that due to becoming the age of superannuation, she has retired. Hence, all the records are in there through the treasury.
Send. Right. Get your instruction.
Lordship, I'll have to obtain instruction from both the treasury officers.
Yes.
But they'll have to, it has to be drawn by one of the treasury officers.
First, get the
Not-
instruction, right?
Yes.
The respondents 7 and 9 are the they can clarify the issue.
9 will clarify, Lordship.
Which 9?
Treasury Officer Dubri. Now, Lordship, I'll have to get the clarification from the Treasury Officer Gosaigaon also. He has made both of them a party.
Mr. A. Chaliha, starting down final instructions. Regard to sanction letters which are issued. By the consent. Instruction is before.
Okay, after 10 days, Lordship.